Alright, dear students, welcome to the ACCA F4. And this first chapter, which we are going to do, is the English legal system, or in short, ELS. I have already told you in the introductory lecture that in this chapter we are going to discuss what is law, we are going to discuss the types of law, we are going to discuss the course structure and few more things in it. So this is the introduction to the English legal system, because I told you that we are studying the law and the variant we are studying is English. That means we are studying the UK law. Alright, the first thing you need to understand what is law. Normally, wherever we are going, wherever we are traveling, wherever we are living, we observe some types of rules and regulations that are being followed by the society in order to live in a proper manner. Like say for example, you are driving on the road, you have the traffic laws. Now, the objective of those traffic laws is to control the traffic. What if there are no tickets? What if there are no challans? The people are not going to follow the law. Similarly, when you talk about the medical, there will be medical laws. Similarly, you talk about the pharmacy, there will be laws, regulations related to the pharmaceutical industry. So everywhere you are going to see the laws. Now, what is law? The principles and regulations established in a community by some authority and applicable to its people, whether in the form of a legislation or of custom and policies recognized and enforced by the judicial decision. Now, remember one thing, that law is actually a formal mechanism. That means it's not something that will be decided immediately, that will be decided at the spot. In fact, these are the principles, these are the regulations that are communicated to the society in advance so that they live in the appropriate manner. As I've given you the example of the traffic, that you already know, like when you are applying for the license, you have to first of all appear in the test. In that test, they actually test whether you are aware of those traffic rules, laws, and regulations. And once you pass that test, then you are being given a license. So the principles and regulations established in a community by some authority. Now, authority can be anything. Like say, for example, you talk about the companies, the laws, principles, and regulations related to the company are being set by the Securities and Exchange Commission. Now, that is the appropriate authority, appropriate institution to make the guidelines, regulations, or principles, whatever you call that. Similarly, you talk about the banks. Now, in your country, there will be many banks. Some of them may be public, some of them may be private. But there is a supreme authority who make all the policies, all the regulations related to that banking sector, and that is the state bank. The state bank is actually the highest public bank, and all the banks work under the state bank. Now, the relevant authority is going to be the state bank. So whenever you talk about a particular department, whenever you talk about a particular institution, there is going to be an authority who are going to make those things. But usually the legislation, the law is made by the parliament. Like we know that every country has, I'm talking about the democratic countries, they're having a parliament, they are members in it, and they are the lawmakers. They will be making the laws related to the every sector. But sometimes they do delegate the technical thing to the technical departments. We'll be talking about that even in this chapter in the English legal system. So it can be a legislation, it can be the customs. Sometimes the customs are much recognized than the law. Like, say, for example, there may be the tribal areas, there may be some rural areas where the customs are much more important, has much more importance than the law itself. So the customs over there can be followed even more than the law. Another definition is the system of rules which a particular country or community recognizes as regulating the action of its members, in which it may enforce by the imposition of penalties. Like, say, for example, if you are not following that particular law, then you may get fined, you may get some penalties for not following it. For example, shooting the birds is against the law. Now, if you are doing that, obviously you are going to get fined for that. All the rules of conduct that have been approved by the government and which are enforced over a certain territory and which must be obeyed by all persons on that territory. So there may be many definitions of law, but you can simply say these are the rules and regulations established and created, approved by the relevant authority, and the people within the society are obliged to follow those principles, regulations, policies, whatever you call it. And then you see there is a term certain territory. Obviously, law will be having the boundaries. Like, for example, you talk about the states, United States. In different states, they have different rules and regulations. So say, for example, you are talking about the particular state, so the law of that state will not be applicable to the other state, like the policies. So there are certain boundaries of the law. Like, there is not a law that will be applied worldwide. Obviously, the lawmakers will be making sure that this law actually has a boundary. Like, say, for example, you're talking about shooting the birds is against the law. What if, what about regarding the people who are living in the jungle, who are living in the wild? Obviously, they are eating those things as part of their food. Like, you cannot apply that law over those people. So the law will be having the boundaries. Now, there are two types of mechanism. One is known as the formal mechanism, another is known as the informal mechanism. Now, no, not everything can be controlled by the law. Like, you can regulate things up to some extent, but you cannot regulate everything. Like, say, for example, you cannot punish people on speaking a lie. Like, obviously, there are people who have unfortunately the habit of lying, and they are speaking a lie. Say, for example, there are people who are spitting on the roads, spitting wherever they are going. Now, you cannot make everything a law. Similarly, if you are hurting someone, like through the inappropriate messages, like, say, for example, if you are hurting someone with your language, not everything can be controlled by the law. So the formal mechanism means that these are the broader things that should be controlled by the law, such as traffic, such as terrorist laws, such as the laws on the companies. They are making products for the society. They should be controlled, regulated, so that they are not making anything which is against the hygiene, against the society, whatever. But not everything can be controlled by the law. So there will be informal mechanism, that is actually the ethics and the morality. So you will be telling the people what are ethics, and these are the things that are not the law. Say, for example, we usually tell the kids that, okay, don't deceive other kids, don't lie to other kids, don't fight with other kids. Now, obviously, this is the law. We are not telling them that these are the regulations. We are telling them these are the ethics and these are the moral values of our society, that you are not going to do a particular thing. So There are two types of mechanism. The formal mechanism is actually the law, and the informal mechanism is the ethics and the morality. Now, the very important topic which we are going to discuss now is the types of law. And the first is the common law and the equity. The second is the statute law. The third is the private law and the public law. And the fourth one is the criminal law and the civil law. Now, first of all, we'll be discussing the common law and the equity. Now, there is a background of this common law. First of all, the common law is the law made by judges. Simply, it's a law made by judges. And then the equity came after the common law, and the objective was to bring the fairness into the legal system. Like nowadays, you probably have seen a judge sitting in the court, and he's actually in the US, and the people are coming over there with their different issues. For example, many are the ones who have been provided the tickets on the speedy driving, harsh driving, fast driving. Sometimes they have parked their car in the places where they were not allowed to park, and they have been provided the tickets, but they have not paid for it. So the people are coming, and actually there are videos on that trial. Probably you have seen on the Facebook or the social media. So the thing is that the judge asked that guy, "You have been provided with tickets, and you have not paid that. And is there any specific reason why you have not paid for those tickets?" And the guy then is coming up with the argument that actually I was carrying a patient to the hospital. That is why I was driving a bit faster. And then I was not finding a place to park. So that is why in the hurry I parked at the place where it was not allowed, and then I went to the hospital to treat that person. Now, obviously, that guy has broken the law in an emergency situation. So it will not be a wiser decision to apply the law over there. In fact, you have to do the equity over there. You have to do the fairness. So you will not be applying the law, but you will be applying the equity over there by removing the fine, by removing the tickets that have been provided to that guy, because he has provided the reason why he has done that act. So we'll be discussing that thing, that is the equity. So the objective of the equity, you will hear that term in the legal system, that equity is something more than the law, to provide the justice, provide the fairness into the legal system. That is the concept of the equity. So common law is a law made by judges. Now there's a background regarding the common law. The background is the war of the Hastings, and uh, when uh, when the king appointed some individuals to roam around their jurisdiction territory and collect the tax from the people, those who are wealthy people, so that the operations of the government can be run properly. So there were some people appointed by the king to collect the tax, and they were roaming around their territory to collect the tax from the wealthy people. So when they used to go to those places, those tribes, those areas, those territories, those places, they were having some issues, and they need some people to make the decision. So what those people who were having the issues, they considering that person who has been appointed by the king, they used to appoint that person as a judge. That okay, you are the person coming from the king. We do respect you. We are going to tell you our customs, and we are going to tell you the issues. So based on these customs and issues, we are actually giving you the authority to take the decision. So those people who were appointed by the king to collect the tax. They used to go to the people, and when they were there, they were being told the issues and they were being given the authority to take some decision as they are representative of the king. So this way, they collected many customs and they amalgamated all of them to make one law of land that is known as the common law. So remember one thing is the common law is the law made by the judges, and how they have made this law, they amalgamated all the customs which they have heard during the trials. They amalgamated all the customs and made one law of land that is the common law. But remember one thing that the remedy in the common law was the damages. Like obviously they used to hear the issues and now they will be actually telling who is the innocent party, who is the responsible party, and the responsible party who has actually done the wrong to the innocent party is going to pay the damages. So the remedy in the common law was the damages. The responsible person is going to give the damages, and this was actually the monetary amount, whatever it was, monetary amount to the innocent party. So responsible party who was responsible for that act is going to give the damages to the innocent party. Now sometimes when the innocent party were rewarded with the damages, they used to go to the king that okay, we have been provided with the damages, but this is actually not a suitable remedy. Like say for example, I have done a contract with you to do a particular task. Money is not important for me, the task is important. So you then later on deny that okay, I'll not be doing this work. Now this is a breach of contract. So we went to the court and I said, this person has not done this task. He said, okay, I admit that I have not done this task. I am ready to pay the damages. But that damages is not acceptable for me. I am looking for another remedy such as specific performance. I want this person to complete this task. I am not looking for any monetary amounts. I just need him to perform that task. So that is known as the specific performance. Or maybe I have done a contract with some person not to do something, and he is doing that thing and saying, "Okay, I'll provide the damages." I do not need the damages. I in fact want that person to stop doing that thing. That is known as injunction. So if they were looking for any other remedy other than the damages, they used to go to the king to ask for that, and then the king used to apply the fairness into that system by providing some more remedies which are other than the damages, such as specific performance and injunction. So this was known as the equity. So first of all, there was the common law. The common law was made by the judges, and how they made it, they went to the different places, and over there they heard those customs. They were being given authority by those people to make a decision on behalf of them. So this is how they amalgamated all those customs and made one law of land that is known as the common law. But the only remedy that was available in the common law is the damages. But sometimes you are not looking for the monetary amounts, you're not looking for the damages, and you need some other remedies such as specific performance, injunction, etc. So they went to the king and they asked for the justice. So the king, because he was the supreme authority, he used to actually overruled the previous decision, and he used to provide another remedy to the people who actually went for appeal to the king. And this is how the equity was introduced after around 200 to 300 years uh, after the common law, and this is how the things were being performed over there. Now, the statute law. Statute law is the law made by the parliament. So you see nowadays the modern laws, we have the parliament for the lawmaking process. So nowadays we see that the laws are made by the parliament, also known as the legislation or the statute. So parliament is responsible for the statute law, and this is also known as the legislation. They can make it themselves, or they can delegate the lawmaking to another authority. We'll be discussing that later on in this chapter. Now, the private and the public law. This is again something very important to understand. Now, say for example, I am going to enter into the partnership with another guy, and that guy has not complied with the partnership agreement, and there's a dispute. Now, the government has nothing to do with our private dispute, but obviously the government does not want any type of tension in the society. So what they're going to do is they are going to make the partnership act, and they will be telling people that, okay, if you are going to do the partnership, make sure you are doing the partnership in compliance with the partnership act or the partnership law. Similarly, the companies, the private companies or the private organizations, whatever they are doing, the government has nothing to do with their private stuff. But the government does not want any type of disruption, any type of frauds, any type of disagreements within the society, because obviously it's not a good thing. So the government is going to make some laws such as company law, the partnership law, employment law, and they will be telling the people that, okay, if you are going to do the employment, you have to make sure you are complying with the employment law. If you are going to do the partnership, you have to make sure that you are complying with the Partnership Act. And if someone has the disagreement, they are going to the court themselves, and then they have to take that person over there, and you will be telling yourself that this person has not complied with the law. And then obviously the law, the judiciary, the judges will be listening to your case, and they will be taking the appropriate decision accordingly. But the government will not be interfering in your private agreements, but they will assist you by making some laws so that it gives you the proper guidelines regarding those private stuff. So private law, law which deals with the relationships and interactions between businesses and private individual groups or organizations. Under private law, it is for individual concern to take the action. If you have some disagreement, so you will take the case to the court yourself. The government will not be interfering in your private matters. But what about the public stuff? Like say for example, you are talking about the taxation. If you are not giving the tax, now you will not be the one telling the government that you are not paying the tax. They will come to you themselves because you are not paying the tax. Similarly, the traffic laws, all other things. So public law is mainly concerned with the government and the operations and function of the public organizations such as councils, local authorities. Within public law, different categories exist. The state prosecutes the alleged perpetrator under the public law. Like, for example, if you have not paid the tax, they will be coming to you, and obviously they will be taking the relevant action, appropriate action themselves because you have not paid the tax. Similarly, if you were driving fast, you will be provided with a ticket. If you have parked at the inappropriate place, you will be handed over the ticket, and you are not going to tell them, but they will actually catch you themselves. So criminal and civil law, this is again an extension of the private and the public law. The private law is the civil law. The public law is the criminal law. So the objective of the civil law is to provide a means whereby an injured party can obtain compensation. Like for example, if there was a partnership and they have broken the partnership with some disagreement, so the civil law means that the law is giving you an opportunity by building the civil courts that okay, you can bring your case over here and you tell the issues, and then we will decide what should be the appropriate solution. So there will be two persons, one who is actually claiming to be the injured person, the other is going to be the responsible party. So the claimant sues the defendant. Now the person who is going to take the case in the court is the claimant and sues. Remember one thing, we are always going to use the term sue for the civil cases. The claimant sues the defendant. Defendant is the person, the claimant is claiming that he has done wrong to him. And within the civil cases, there should be prove the wrong on the balance of the probability. Now, the balance of the probability simply means that you are not going to give the absolute assurance, the 100% assurance within the court. In fact, you have to prove the balance of the probability that gives the complete flavor to the judge that okay, what the case is. But in fact, in the criminal case, the state prosecutes the accused. Now, remember one thing, that in the criminal cases, we are going to use the term prosecute. And who is going to prosecute? State is going to prosecute the accused. And in the criminal cases, the state has to prove beyond reasonable doubt. Now, once you understand beyond reasonable doubt means there should not be any sort of doubt. There should be 100% an absolute thing. The state needs to prove that this person is actually guilty, this person is actually convicted. But in the civil law, it should be a balance of probability. If proved, defendant is held liable, responsible. If proved, the defendant is found guilty or convicted. You are not going to use the term guilty in the civil cases. The remedies will be damages, specific performance, or injunction. And the case will be referred in the court by the name of the party. Say, for example, X versus Y. Here, the remedies are going to be the fine, punishments, imprisonments. And the case is announced in the court, state versus accused, or the crown versus accused. So these are the major differences. In the civil law, we use the term sue. In the criminal law, we use the term prosecute. In the civil law, you have to prove on the balance of the probability. That means there is no need to give the 100% or absolute assurance. If you have if you have proven that thing on the balance of probability, that means to the major extent you have proven, then that's fine. That will be actually acceptable. In the criminal law, the state needs to prove beyond reasonable doubt because again, because of the actually remedies over there, fine or imprisonment, there is actually the punishment over there, so there should not be any doubt. Can a case, before discussing the system of the courts, can a case at the same point in time be a breach of civil law and the criminal law? One case, both the breach of the civil law and the criminal law. Yes, it is possible. Say, for example, if you are drunk and you are driving and you have hit someone, so these are two cases. You were actually drunk, so this is the criminal law. You have hit someone, so now that is going to be a civil law. Now, this case at the same time is actually a breach of the criminal law and the civil law.